Thank you, Kevin. It's a pleasure to be here. Just to give a little bit more of my own background as well, I teach courses in patent law, intellectual property, and property law at George Mason, and I have spent almost the entirety of my academic career researching the intellectual history underlying the development of Anglo-American patent law, beginning in England and then up through the United States. And this has entailed me doing things like reading all reported patent decisions from the 19th century. There's about 1,400 of them. Really exciting material, but actually it is. At least I found it to be. And I'm happy to be here to speak about the problems, the constitutional problems that were touched on by Jonathan with H.R. 1249, the American Invents Act, and the underlying historical interpretation of the Constitution as it's been applied to the patent statutes by congressmen and by judges throughout the 19th century. Now, in 1859, President Abraham Lincoln very famously declared in a speech that, quote, "The patent system secured to the inventor for a limited time the exclusive use of his invention, and thereby added the fuel of interest to the fire of genius in the discovery and production of new and useful things," end quote. And notice there, secured to the inventor for the discovery and production of new and useful things. And by the way, President Abraham Lincoln knew exactly what he was talking about. To this day, he's the only president who had received a patent himself, and which was enforced at the time he made the statement. So it was almost self-referential, I suppose. So, but the point of reference here is that this is just not rhetoric by President Lincoln. He was speaking about how the Constitution has secured to inventors their property rights and their inventions throughout American history. As people well know, Congress does not have unfettered discretion in adopting patent laws in this country. They are guided by the Constitution as identified by Jonathan in Article 1, Section 8, Clause 8, which reads that Congress have the power to promote the progress of science and useful arts by securing to limited times to authors and inventors the exclusive right to their respective writings and discoveries. You need a Constitution. There's an out for that. And the operative term here is inventors, as Jonathan touched on. In the founding era and throughout the early years of the American Republic, in which Congress and the courts constructed the basic rules of what we now take for granted in the American patent system, they constantly recognized that the patents secured to first inventors, not first to filer, but the first inventors, their property rights. As Chief Justice John Marshall recognized in a court decision as early as 1813, quote, "The Constitution and law, taken together, give to the inventor from the moment of invention and an inchoate property therein, which is then completed by suing out a patent," end quote. Notice, the Constitution and laws give to the inventor from the moment of invention what was he called an inchoate property right, meaning a moral property right, and that you perfected by obtaining a patent. In the same way that first possession in land creates a moral right to that land, to which then you perfect by obtaining a title to thus secure it legally under the laws of the country. Now, interestingly, much of this history has been forgotten today, and many people don't realize how the American approach to securing patents to first inventors was extremely distinctive. It was part of the American exceptionalism, the founding era and the antebellum era. It was part of one of the many aspects of what distinguished America from not just other countries, but even more importantly from England. Other countries, including England, of which Americans were very much well aware of, viewed patents not as securing property rights and inventors, but they viewed them as special privileges doled out by the government to achieve various economic and regulatory goals. The American founders and follow-on early American judges and congressmen understood this English tradition of creating monopoly rights and broke with it, just as we broke with England to secure other rights of the American, what were then American colonists, in which became American citizens. And thus, they created a set of legal institutions and rules built around the rule of law securing property rights to inventors. And thus, it's not unsurprising that one finds constant references to natural rights philosophy as the moral force which drives the security of patents to inventors. Daniel Webster, the great orator, the antebellum era, also a prominent figure within patent law, often represented patentees before courts and adjudicated patent disputes, declared in the House of Representatives in 1824 that, quote, "The right of the inventor is a high property. It is the fruit of his mind. It belongs to him more than any other property, and he ought to be protected in the enjoyment of it, end quote. And this was not unusual. One finds constant references to these types of beliefs throughout the early records of courts and Congress. In 1845, Supreme Court Justice Levy Woodbury wrote in a patent case that, quote, "We protect intellectual property, the labors of the mind, productions and interests that are as much a man's own and as much the fruit of his honest industry as the wheat he cultivates or the flocks he grows," end quote. Now, one might be tempted to say, oh, well, that's pretty rhetoric. You know, this is what they were adding as kind of flowery ways to, you know, make their opinions and statements sound good, especially to Americans who like things like fruits of labors and owning something. But this was not just rhetoric. They actually actively relied upon common law property concepts, doctrines, and rhetoric with respect to other types of property like property rights and land in creating patent doctrines in this country. Thus, early American courts constantly cited to and relied upon cases decided by American courts and English courts adjudicating disputes over land as precedent for deciding patent cases. They incorporated into the patent laws the exact same doctrines that govern how people transfer property interests in land. They adopted those and transferred them into patent law, even adopting the same property concepts, assignments and licenses, for defining how and what's the nature of the property interest that is obtained by someone who contracts with the patentee. They provided constitutional protection to patentees under the Constitution, something that was denied in England and it was denied to all other recipients of special government franchises, special privileges. Thus, when the government engaged in unauthorized uses of an invention, this was deemed to be a taking under the Fifth Amendment of the Constitution. And the courts repeatedly held this throughout the 19th century. And in fact, in a very prominent case in 1878 called McKeever versus United States, the court held explicitly that that patents were secured under the Takings Clause, and went on to note that the framers quote, had a clear apprehension of the English law on the one hand and a just compensation on the other of what one of the commentators on the Constitution has termed a natural right to the fruits of mental labor, end quote. Meaning that property in inventions secured as patents has the same status as property rights in land that is also secured through one's labors. I'd just like to emphasize also, as someone who has read a lot of the historical record on patent law, that the complaints today about the patent system, that it's costly to administer or that it just serves the interests of monopolies, these are nothing new. These criticisms have been made by patent skeptics since the inception of the American patent system. And 19th century judges repeatedly responded to these arguments. They had to, because juries could be swayed by them, and they were made by lawyers in patent disputes. And thus, for instance, Justice Noah Swain, another Supreme Court justice who was presiding in a trial in 1869 involving a patent infringement claim, he had to instruct the jury that, quote, "The rights secured by a patent for an invention or discovery are as much property as anything else, real or incorporeal. The titles by which they are held, like other titles, should not be overthrown upon doubts or objections. This principle should be steadily borne in mind by those to whom it is entrusted the administration of civil justice," end quote. The right secured by patent for an invention, meaning the right secured to the first inventor. The entire understanding of patents as property rights that secure the fruits of one's intellectual labors only makes sense if one understands that patents are not granted to simply the first person who wins the race to the patent office, but actually goes to the person who is responsible for creating this new technology. And thus, in the words of Justice Swain that I just quoted, we should not radically overhaul and change the patent system given, quote, doubts or objections, unquote, to how it functions today, or even given treaty commitments with countries like England and other countries around the world. The Constitution and the resulting statutes and court decisions that have secured property rights to the first inventors for more than 200 years really deserves no less. So, thank you.